Okay. We are very pleased to be having our keynote luncheon today. I hope the morning sessions have been going well. Yes? Yeah, give me a big thumbs up if you are enjoying the day. Thanks very much. And this is going to be a working lunch because we had a full day of events. And so we decided to make this a working lunch. And we are just so thrilled to have Professor Schertz and General Counsel of the CPPA here with us. I'm going to introduce Professor Schwartz, and Jenny is going to introduce Phil. Thank you so much for joining us as a moderator. Professor Schwartz is a leading international expert on information privacy and information law here at UC Berkeley. We are just so excited to have him. His scholarship focuses on how the law has sought to regulate and shape information technology, as well as the impact of information technology on law and democracy. As you know, this is the primary topic of today's lab, a Privacy Plus AI Lab, and so we're just so thrilled he was able to join us. He is one of my favorite professors here at Berkeley. He is a past recipient of the Berlin Prize Fellowship at the American Academy in Berlin and a research fellowship at the German Marshall Fund in Brussels. I have a feeling you speak German. A little bit. And he also has received grants from the Fulbright Foundation, the German Academic Exchange, and the Harry Frank Guggenheim Foundation. He is a member of the organizing committee of the Privacy Law Salon, which is another great conference. And so I will do a plug for the Privacy Law Salon for Professor Schwartz, and also of the American Law Institute. So welcome, Professor Schwartz.
My privilege to introduce Phil Laird, our speaker. Or am I not on? Oh, just closer. Okay. Phil Laird, as many of you know, is the General Counsel of the California Privacy Protection Agency. But Phil, when I look at his background, has had a life of public service, really dedicated to our state. So before joining the ranks of enforcement for privacy, he was Deputy General Counsel at the California Business Consumer Services and Housing Agency, where he provided legal advice and guidance to 11 state departments and boards. Prior to that, he served as staff counsel at the California Horse Racing Board, working on rulemaking enforcement matters. I bet there's a lot of fun stories about that. And also Special Deputy Attorney General at the California Department of Justice, advising on education, law, and policy. He holds his bachelor's degree from UC Santa Cruz, and the shout out, JD from University of San Francisco, where I teach. Love USF Law and their students and their alums. So we're really excited to be here, and thank you for joining us. And I have to say, personally, I'm impressed with what you do at those meetings, Phil. Like on the spot, you know everything, and you are great. So we're really looking forward to this.
Thank you. It's so exciting to be here. It's really cool. I'm looking around the room. I'm seeing friends from all over the country. That's really awesome to see familiar faces. Also, I'm just sitting up here looking at this amazing room. I feel like I'm in craftsman heaven. If you just saw a picture of this and knew about the great weather and got 3 guesses, I think it would take 2 seconds to say I must be in Berkeley. So welcome, everybody. I'm going to just have questions for Phil, but I want to start off by just highlighting some of the very exciting developments in California privacy. So October 8th, this week, 2 additional states, Minnesota and New Hampshire, joined the National Consortium of Privacy Regulators, a bipartisan effort, which was first announced in April 2025. It's a statewide group that implements and enforces state privacy laws and joins in nationwide enforcement at the state level. So who's in it? We've got California, Colorado, Connecticut, Delaware, Indiana, New Hampshire, New Jersey, Minnesota, and Oregon. Pretty big deal. Next, California continues to enforce California's privacy laws, the CPPA, Let me tell you about some of the recent actions. So requiring Tractor Supply Company to pay a $1.35 million fine for CPA violations. Issuing a decision regarding the clothing retailer Todd Snyder to change its business practices. There's a $345,000 fine. A decision requiring American Honda Motor Company to change its business practices. $632,000 fine. Settlement agreement involving data broker background alert. And then finally, I have to say I found this fascinating with my background in international privacy law, a partnership between the CPPA and the data protection authorities in Korea, France, and the United Kingdom to share information and advance privacy protections for Californians. So forget Hollywood and the Avengers and the Justice League. We have new forces for privacy justice. Okay, so the CPPA has been very, very active. As Larry David used to say on Curb Your Enthusiasm, pretty good. So let me shift now to questions and with Phil. And so what do you think are the 3 top enforcement trends that we see in 2025?
Thank you, Professor Schwartz, and thank you, everybody, for being here today. Thank you to the organizers for offering me to speak to you for a little bit. So to begin, coincidentally, in some regards, I'm kind of the wrong person to be talking about enforcement, but I'm going to explain that for a second. So for those who aren't aware, our agency has both the adjudication function and the enforcement function in the same house. And so as a result, what that means, our board is the final adjudicator of any administrative action that is taken against a business, for instance. And it means we have an enforcement division full of attorneys, support staff who essentially are prosecuting conducting these investigations, prosecuting these actions. At the same time, my division has other functions. We advise the agency generally, advise the director, advise the board, but especially when it comes to making a final decision and adjudicating an action brought from the enforcement division, we're advising the board. So this is to assure you, I am walled off actually from everything happening in enforcement until it essentially hits prime time. So just, from that perspective, recently our Deputy Director of Enforcement, Michael Macco, announced at a board meeting that there's literally hundreds of investigations open. And I'm sorry to tell you all, I know nothing about those, and I won't be able to reveal that now. But with that said, I do have the opportunity to sit with the board in closed session when they decide to adopt a settlement, for instance. And I think the settlements themselves tell a story of the progress that our agency is making, that our enforcement division is making, that's fascinating, but does have themes to it. So I will answer your question after all that preamble. So 3 cases you mentioned under CCPA in our agency's history so far. So the first one being the Honda case. And that really stood for 2 primary principles. And that is exercising your opt-out rights should be easy to do, and that businesses must protect consumer PI that it discloses to other people, for instance, by having proper contracts in place. There, I think one of the highlights was a failure of symmetry and choice in just the opt-out presentation for consumers. This is something that you see actually then recur, opt-out. Making opt-out easy is a theme, I think, across the enforcement actions you've seen to date. In addition, I think something notable about this is not just the fine or the violation, but it's the additional requirements on the business. So for Honda, there was actually a requirement in the settlement that they engage a UX designer to ensure they're avoiding dark patterns, to ensure they really are offering symmetry of choice. And again, I see that not just as an interesting one-off of something that happened to a business in enforcement action, but more of a great recommendation to businesses that aren't necessarily a target of enforcement action, what they might want to be doing proactively to avoid that situation in the future. We also had the Todd Snyder case, and there I think you also saw an instance of a business that was maybe over-reliant on a third party to be their compliance, and it's a good reminder that the business who is subject to the CCPA is the business that's liable, regardless of how you are approaching compliance, whether or not you're contracting that out or relying on other parties. You need to do your due diligence to make sure your house is in order. And then finally, with Tractor Supply, this is another one where, again, you see businesses needing to review privacy notices and opt-out mechanisms, make sure that your opt-out is actually working, make sure that the receipt of opt-out preference signals are actually being processed and implemented and not just a signal that goes nowhere within the business. Additionally, it added the component of applicant data. So I think it's the first settlement decision you've seen where we're actually talking about employee data now, which is subject to CCPA. So those to me are some of the highlights of those decisions, at least from my side of the aisle, so to speak. And but again, what I'd encourage everybody to do, more so than looking at the fines or anything like that, I think look at the remedies, look at the things where the agency has suggested or influenced how a business is actually going to right-size the problem. I think that's a really great indication of how businesses can be proactive about these issues.
That's terrific, and it's interesting thinking about those 3 enforcement actions that you highlighted. So we've got just a whole mixture of really cutting-edge issues, dark patterns, the obligation to have information, have your oversight and your compliance follow the information, so you can outsource legal liability. And then also the fact that employee data is now covered, and in Tractor as well, kind of the ongoing, long-standing issue, how do you get notice right? So really, really interesting. Next question. Can you tell us about the delete request and opt-out platform that the agency is going to be releasing in 2026?
Yes, I can. And that's a good pivot because that's something I do know a lot about. Again, a little inside baseball is new agency, new functions come online. It means sometimes random people get random jobs. And so the legal division was actually tasked with being sort of the primary group to stand up this platform. Don't worry, it doesn't mean attorneys were actually doing the engineering work. I want to be clear about that. That is not what happened. But we have been highly engaged in the development of this process. And quickly, I'll just say, to me, it's actually been a great model, at least in state government, and I think this crosses over to business, private sector as well, of how valuable it actually is to have attorneys on the ground at the beginning of a project to be helping influence the design of a system, the implementation, the choices being made sort of as you go from concept to execution of a new program. In a way, I've had to live in your shoes a little bit, although not subject to CCPA. We actually, in some ways, have a more strict law for government, the Information Practices Act, certainly stricter data minimization standards and things of that nature. And so I've had to be thinking about a lot of this, okay? And it's complicated, but it shows, I think, the value of having sort of collaborative teams between your engineers, your developers, your program managers, your public affairs office even. It's quite the endeavor. But so in a nutshell, if you've not heard about this before, the delete request and opt-out platform, I'm going to call it DROP for short. That's what the agency's going to call it, all right? You can call it DROP and we'll know what you're talking about. DROP is a first of its kind. The pitch we like to give is do not call list, but for data brokers. And so essentially, it's going to be a portal only hosted at the CPPA's website where California consumers can come in, type in limited information about themselves, and send a single request that will go to all the registered data brokers in the state saying, delete my personal information. Pretty cool, right? We're excited about it. We think this is a really innovative thing that's being introduced, and we understand a lot of states are interested in what we're doing nationally. I think there's a lot of eyes on this project, and we do think it's going to be very successful. So it launches January 1st, but January 1st is when consumers can come in and start entering their information. Data brokers won't actually be required to delete information until beginning August 1st of next year. But at that point, the system will be fully functional. But a note of caution to everybody here. Read the definition of data broker and read the definition of direct relationship. I mean this, because I think there's a potential misconception for a lot of businesses out there that, oh, I'm not a data broker. I do directly interact with my consumers. But if you read it carefully, it describes the situation of a business that might actually have direct relationship in some capacities and indirect relationship in other capacities, and that is still a line of business that is subject to the Delete Act that requires registration and will require information deletion beginning next year. So again, highly encourage all the bright minds here to just take a look at that if you haven't, because it could be very meaningful for a number of clients out there, I promise. So in a nutshell, again, I think this is a very innovative tool. We're trying to make it as simple for consumers as possible. And I think we will get to see in real time sort of how much of a shift this has in both business models and consumer perception of privacy.
That's great, and it's really interesting what you said about data broker being state of art that could possibly trip up companies, and we've seen this before in privacy law. One example that comes to my mind is the definition of financial institution in GLB, where it's so many companies are kind of like the legendary ostrich with its head in the sand, thinking, well, we're not a financial institution. And it's like, look at the regs, you are. Example would be the title insurance companies, right? So absolutely. Another example would be also from Graham Leach Bliley, from kind of lessons we have learned in data privacy law, what's non-public information, right? Where many companies under GLB Act think just because the information is sort of out there somewhere and is sort of public, it doesn't matter that they're receiving it from their customer. Not true, right? And so there definitely are all these tripwires. And I can see how data broker is something that companies should be very cognizant of. Let me ask you a quick follow-up on that, Phil. To what extent can you tell us about guidance from the CCPA, both formal and informal? Here we have a audience of leading California privacy lawyers. How best, most effectively, most efficiently can they interact with your office?
Yeah, that's a really great question. Obviously, we're still a small and growing agency. I think we're past our like newborn stage, but people have acknowledged maybe we're like teenage at this point. But no, we're at the same time. First and foremost, I mean, I think anybody on our staff would say, if you reach out to us, we make every effort to respond. So please understand that we would love to connect with people interested and concerned about privacy practices or privacy concerns. We engage absolutely to the extent possible. At the same time, I do have to acknowledge there's an interesting, I won't call it a conflict, but a constraint that exists actually from another law. So as you know, if you've read CCPA and at least the requirements of our agency, and something we truly want to do is education, right? Consumer education, business education. At the same time, quick little like procedural state government rulemaking lesson. Under the Administrative Procedures Act, essentially the law states that any state department or agency cannot, let me see, I'm going to try to do it off from memory. It's implement or establish or implement a rule of general application that implements, explains, interprets, or otherwise carries out a law without going through rulemaking. And so my point being there, please do pay attention to our regulations because they are lengthy. Sometimes they may seem complex, but they're full of illustrations and examples. And that's in part by necessity, right? We can't just come out with extra guidance about what exactly a certain regulation means without actually going through the rulemaking process. So if ever you felt frustrated, why doesn't the agency say more? I'd actually love to hear that. And then where we would take that is maybe there's an opportunity to clean up our regulations. Maybe there's an opportunity to provide additional clarity so that every business has the same knowledge and understanding of what's required of them. I will tell you my personal goal is never to have a gotcha scenario with anybody. I can absolutely imagine myself being in the place of a business saying, just tell me the rules and I will follow them. And so my goal is to tell you the rules. If we're not telling you the rules, if you don't know how to follow them, that's something I'd love to hear about. Please reach out to me. I think we'll put my email or my card out somewhere, okay? And then that's truly an open invitation.
That's so helpful. That's so kind. Also, as you were speaking, just for future thought, as there are going to be parents in the room with kids at different ages of development. And so when you describe the CPPA as being at the teenager stage, that may have struck terror into the hearts of people. So by design. Okay. Well, then you're the boss. I would like to think you're at the happy toddler stage, like out of diaper, sleeping through the night, loving mommy and daddy. I don't know, but you know best. You
Well,
worked there.
coincidentally, I have twin 2-year-olds, so that's actually triggering for me.
Okay, good point. Let me ask you about the latest ADMT rulemaking. This rulemaking concerns automated decision making, of course, and it is a big deal. And so, what are the key compliance requirements? What are the key deadlines?
Yes, thank you, and I'm happy to speak about that today. So, for folks who've been following the agency at all, you know we've been talking about these regulations for years, pretty much since the agency's inception. I think our first official RFI went out September 2021, but I'm happy to report that we just last month, gosh, I'm losing track of time, had approved these regulations, and they take effect January 1st. And so there's a lot to them. There were updates to the existing regulations that were adopted several years back. Many of those which do take effect right away on January 1st of next year. There was also some clarification for insurance businesses around sort of the application of sort of dual regulatory schemes there. And then in addition, there were components on automated decision-making technology, risk assessments, and cybersecurity audits. One thing that I thought was very thoughtful and careful for the board to do was to give compliance lead time for these new requirements for the parts that weren't already implemented in some capacity. So starting with automated decision-making technology, and I do want to acknowledge, again, these are born out of Proposition 24. These were new requirements to do rulemaking on these topics. And for automated decision-making technology, we were given the following line. Basically to implement regulations governing the opt-out and access rights with respect to automated decision-making technology. And as everybody here probably knows, none of that was defined. So that was on us to figure out and strike the right balance. And so that was part of the years-long debate between our board, our discussion with industry, listening to stakeholder engagement on these issues. But at this point, the ADMT component of the regulations have been finalized. Essentially, they address the business use of technology that processes personal information to make significant decisions without human involvement. Each one of those is like a little breakdown, like law school quiz, right? The decisions in scope are those that result in providing or denying financial or lending services, housing, educational or employment opportunities or compensation, or healthcare services to a consumer. So what does that mean? It means if you assess the technology you're using and the way you're using it, if you're a business and it falls into one of those categories and it doesn't have human involvement as that's been defined in our regulations, beginning January 1, 2027, we got a whole year plus of runway to get houses in order and get prepared for this. There's essentially 4 main things you need to be doing going forward. And that is, first, you'll need to do a risk assessment about that activity. Secondly, once you're actually launching that activity, you'll need to provide consumers with a pre-use notice, notifying them, hey, ADMT is about to be used with respect to you to make a significant decision about you. At that stage, then it'll also inform them, you'll have the opportunity to opt out of this if you'd like. That's the third component, opting out, giving consumers actually the ability to opt out of the use of ADMT. And then finally, if a consumer decides to use the ADMT and move forward and not opt out, it's giving that consumer the ability to access meaningful information about how the ADMT was used with respect to them. And this is sort of a bespoke little readout that needs to come to the consumer that explains what happened in their situation, not just a generalized statement that would apply to everybody. So those are the 4 components. Now, with that, there are plenty of exceptions. I just want to make clear. If that sounds super scary and you weren't paying attention, you're thinking, oh, crap. Let me assure you, there are a handful of caveats that apply. So from the definitional stage, human involvement, that's defined. It's defined in our regulations as involving somebody who can understand and interpret what the readout from an ADMT is, that analyzes it and considers its output, and then that has the authority to overturn that. That means you have somebody involved who doesn't have to just listen to what the ADMT tells them. They can actually think about, analyze, and do something to overturn it if there is an error or some other reason why it's appropriate to overturn the decision of a system. So if you're in that boat, you actually don't have to comply with any of this. You don't meet the definition of ADMT, essentially, or being subject to these requirements. If you don't do that, though, you don't have a human on the front end. There's an exception, at least for the opt-out component, if you have a human appeal option on the back end. So essentially, if after that process happens, you've set up a process where the consumer can then say, hey, I think something went wrong. I'd like to appeal that decision. And there's somebody there to take that appeal. Again, you don't actually have to offer the opt-out at that stage. In addition, there's a limited exception for the allocation and assignment of work or compensation decisions that essentially, if the technology is deployed in certain ways and is given general assurances of not being discriminatory and a few other components, you can deploy that without having the opt-out component involved. So I recognize that's a lot. I just told you I don't expect anybody to remember that. And I do promise you we're going to have a lot of business education we're doing over the next year to really make this easy, give you all the checklists and webinars your heart's desire. I promise to make this easy for you all, to make this easy for businesses, because we're not a gotcha organization. It's all about trying to make compliance happen on the front end. In addition, I'll just mention then briefly, there are risk assessment requirements now. This is very, similar to things you've seen internationally, right? Data privacy impact assessments or other aligned concepts in the past. You now have it in California as well. It was said at our meeting, I'm just going to say it again, if you look at our regulations and you see the example about another jurisdiction that has crossover, and we give an example of what you'd have to add on to that jurisdiction's risk assessment, it was Colorado's. Okay, I'm just going to tell you now. So if you already know the Colorado one, look at that, and we've done the breakdown for you, at least in that regard to that state. And then finally, so I should be clear, with risk assessments, the rules state you don't have to be in compliance if completed a risk assessment until January 1st, 2028. 2 whole years, look at that. However, if it's a new activity starting January 1st, 2026, so just around the corner, if it's a brand new activity that a business has not engaged in before, they need to do the risk assessment before they start the business. So in some regards, that one actually triggers very quickly. Any business looking to bring on a new processing activity subject to those requirements, beginning January 1st, better have a risk assessment before they do so. And then finally is a cybersecurity audit requirement, which is another novel thing, I think, at least in the US and certainly in California. It's a requirement that certain businesses are going to have to conduct cybersecurity audits regarding their personal information systems on an annual basis. And there's a phase-in for that as well. So businesses making 100 million or more have to do this in 2028, 50 million or more in 2029, and the rest of businesses subject to this requirement have to be in compliance by 2030. Again, 5 years, guys. We can do this. I have faith in all of you. We can get it done. But with that said, that's in a nutshell. I'm sure there's plenty more we could dive into on that. But
this is really fascinating. It's to my eyes, a fascinating example of global convergence. So in the GDPR and the Data Privacy Directive, going back to the French National Data Protection Law in the 1970s, there was a restriction on automated decision-making that roughly tracks kind of where California winds up in 2025. So that's really fascinating. The other thought that I also have the definition of kind of threshold requirements. And it was funny you said this is like a law school exam, because as I looked at it, I kept thinking, well, is there a gap? Is there a problem? So let me just read that to you again, and we can all think about it together, and tell me if you think in the future there's some area that should be added to it or taken out, subtracted. So as you read, any technology that processes personal information and uses computation to replace human decision-making or substantially replace human decision-making, with the kind of exceptions that you mentioned. If there's a human at the end of the process, you're good to go. A human who can do thumbs up or thumbs down on what the automated decision-making led to. Then, what are we covering? Financial lending services, housing, education enrollment, employment or independent contracting, and then healthcare. So anything, I mean, that it seems to me to kind of at least initially cover the waterfront.
Yeah, it's a great question. I mean, that list, again, I won't assume everybody was tracking sort of each version of these regulations as they came out, but obviously there was a starting point was to look to other jurisdictions, right? See what Europe was doing, what they considered significant decisions, look what other states were considering in Colorado, for instance. And at the same time, I think we had to then focus on decisions where we thought there was the greatest potential harm to consumers, where we thought there was the greatest potential for abuse and use of these systems, and maybe not intentional abuse, but really just accidental bias that could be occurring as well. And then we also had to acknowledge the constraints of our law. It's not something I'm going to speak at length about, but I think if you look at the CCPA, you know there are exemptions. You brought up some sectors there where there are exemptions for certain data held by certain entities that won't be subject to this because of those exemptions. But at the same time, we recognize not everything that people think of when they think of healthcare data is covered by HIPAA. Not everybody thinks of as financial data is covered by GLBA. And so we wanted to make sure that, and I hope businesses are meaningfully looking at sort of where one line ends, the other one begins as far as we're concerned. And so if you're exempt on one of those, that's fine. You're subject to those laws. But if you're not, you should really be paying attention to these requirements.
Thank you. Let me ask you, where do you see the regulatory priorities being for 2026 and beyond?
Also a great question. So I'll start by saying I'm not the decision maker. In fact, as any attorney will say, I'm just the advisor. I don't make any decisions. I just give advice and it gets ignored sometimes. With that, we are overseen. We have a relatively new director, although even he's getting to his toddler stage. He's been with a great addition to the agency, Tom Kemp. But then we're also overseen by our board, our 5-member board, who really does set the policy goals and standards of our agency. But we're at a really interesting moment. For folks who've been paying attention, our rulemaking has been almost entirely focused on everything that we were told to do under Prop 24. And now, finally, we're done. We've completed that phase, which means we get to now turn our sights towards, and sort of to what you were alluding to, what could be better? What needs further clarification? What is a consumer protection that isn't quite clear or isn't best implemented yet, but could be done better in our regulations? What's better notice? What's better consent look like? Where is there confusion for industry? So I do anticipate, I'll even preview for you all, you get insider scoop here. I do think in the next meeting or two, the board will be starting to talk about, okay, what's this next wave of rulemaking we want to take on? What are the things we want to start investigating? What are the things we want to solicit more feedback on? And I think it'll be much like our previous processes. It'll start with high-level concepts, high-level questions, and it will be so meaningfully driven by the input folks here and beyond provide us about where they think there are issues. Again, I mean it when I say businesses, practitioners out there that see lack of clarity, that see gaps in what we have on the books already, let us know. That's room for improvement. That's room to do rulemaking right away. So I think rulemaking could tackle any number of fairly big issues. Some of the ones I mentioned, one I know, again, that's came up in Tractor Supply, we've mentioned already, employee data. I think we all know that the current laws and regulations applies to employee data, but we recognize it's probably more helpful if we add a little more context for businesses. So I anticipate more coming in that regard. And that's another open invitation. If you can think of ways where you're saying, hey, I'm running into a conflict. I don't know what to tell my client. I don't know how to handle this. Let us know. Let us try to figure this out through rulemaking.
Oh, that's very helpful and encouraging. A couple more questions. So I was fascinating to read about your partnership with Korea, France, and the United Kingdom, in particular the data protection authorities there, and any insights you can have. I'm sure that in this room we have folks who have international compliance tasks on their plate. So what is that looking like, and where do you see it going, this partnership?
Yeah, that's, again, wonderful question. Our international partners are invaluable. First and foremost, as relatively new kids on the block, we, of course, want to look towards our more established international partners for lessons learned, for best practices, for sort of advances they're making to make sure we're not too far behind in any regard. I will also share, maybe to some people's chagrin here, some of this was obviously motivated from our enforcement division and wanting to be able to connect and sort of share resources or best practices from an enforcement lens. But I really do assure you, the agency is using these opportunities to learn from each other, to share with each other. For instance, we actually just recently hosted for a day fellows from, it's called the Hubert Humphrey Fellowship, run by the State Department, and we hosted fellows from Australia and from the Irish Data Protection Authority. And it was great because they never heard of drop. And so we got to tell them all about drop. And they were, they were astounded by this concept, and they were saying, oh, we're going to take this back to our governments. This is going to be great. At the same time, there was stories they were telling us and lessons learned that were really insightful, interesting, and cause us to reflect in our today business as well. So without going too much into details that I can't, I'll just say the partnerships are fruitful. And they sort of across sort of both policy enforcement and alignment sort of have various benefits that we're really fostering.
Very helpful. And while we're talking about kind of cooperation, enforcement, tell us about the dividing line with the California AG's office. And it's kind of an interesting ballet with different kinds of enforcement possibilities. So how is that shaping up?
Yeah, good question. I mean, you'll notice Stacy's never in the room if I'm in the room. I'm kidding. That's a joke. I mean, obviously it's our enforcement divisions that probably work the closest together. And it really is a partnership from my perspective, at least. Again, Stacy was here. I don't know if she'd be shaking her head no or yes. But no, from my perspective, it's a really valuable partnership. The truth is, from a regulator standpoint, having two people do a job as opposed to just one is good, right? It means we can divide our resources. It means we can have a greater impact in sort of how we investigate and enforce activities. At the same time, there's a continuing partnership at a higher level, at a policy level with the Attorney General's office, to the extent that you continue to see legislation passing right now that gives the Attorney General's office some rulemaking and enforcement authority over privacy or privacy-adjacent topics, and you see some coming to us. And at the same time, what we don't want are dueling standards. We don't want confusion for industry. So we line up, we talk, we consult each other out to the extent that we need to be in coordination to have a good impact, again, from an enforcement angle, but also to have a good impact on a policy angle as well.
That's super helpful. You've talked about the ADMT regulations. I'd like to ask you as well, there have been really important, pivotal CCPA regulations now on cyber audits and privacy risk assessments, which you've alluded a little bit to. I wonder if you want to say anything about that.
Yeah, I'm happy to go a little further into the cybersecurity audits. As I mentioned, this is novel. I'm pretty sure it's just a financial sector in New York that had a cybersecurity audit requirement. And at this point, we're the first state to really require businesses to comply with this. And in case you don't remember what the threshold is, okay, so first of all, you have to be a business who is subject to CCPA. Okay, we've crossed that threshold. Second threshold is if you derive 50% or more of your revenue from the sale of personal information, you're going to have to do a cybersecurity audit, regardless of your revenue. Second, alternatively, if you're a business that makes more than that minimum gross revenue threshold, 26.6 million right now, and you do certain processing at a higher level than just sort of the basic rates, so to speak, you will also have to do a cybersecurity audit.
If I can help out since I have it in front of me, right?
Yeah.
So absolutely. So CCPA annual gross revenue threshold, about 26.62 million. And so it's kind of gets complicated here, but we love it. We're lawyers. Process the personal information of at least 250,000 consumers or households. And that's, of course, an innovation in California. That household information becomes PII, big deal. Or process the sensitive personal information, and so then it kicks in another definition for our enjoyment, sensitive personal information of 50,000 or more consumers, or, so that's all one, and then it gets to two, does the business derive at least 50% of annual revenue from selling or sharing personal information? And what's going on, I think, in two is the notion, as Bruce Springsteen said, from little things, big things one day come, right? So it could be a startup and it's all about personal information, and so 50% of their annual revenue, and they can't just say, oh, we're little, leave us alone. We're not yet doing at least 250,000 consumers. So that's the audit requirement, and if you meet any of them, cybersecurity audit time.
That's exactly right. That's exactly right. And it is an annual audit requirement. That was a part of the actual underlying statute, so there really wasn't flexibility for the agency there. But exactly, you have to undergo these audits. But in many ways, these audits, I think some of you might agree, are probably appropriate given the nature of the information, given the sort of diversity of approaches to business and the ways businesses manage it or maybe don't manage their personal information. I think this is going to be very illuminating potentially for a lot of businesses. And then again, with the goal of getting everybody's house in order and not necessarily having it all end in an enforcement action, but maybe have compliance start sort of by choice as a result of these audits, I think you're going to see a really big impact. This was also, I'll just note something really something emphasized by our chair at past board meetings when discussing this. Essentially that, cybercrime is out of control these days. I mean, the cost, not just to consumers, but to businesses right now is exceptional and growing. And so we really do believe this is something that'll actually help businesses. Sometimes it's hard to take your medicine, but the medicine makes you better, right? So in that regard, I think we're eager to see the results of this play out because we think it's going to end up in a better position for businesses and consumers alike. And same goes with risk assessments, really, right? It's really the goal of both of these requirements are pause as a business and take a look at what you're actually doing, consider the risk, consider the benefits, consider the gaps and potential mitigations, and then carry on, right? It's a real gut check for a business, and it helps ensure that we're all sort of performing at our best. And so I think those are the key themes behind those two requirements. And again, I think you see those play out for a number of years. I think you're going to see an improved environment generally, an improved commercial environment for everyone in California.
Well, thank you so much. And to offer my own little perspective on this, it's really interesting that the cybersecurity audit follows deepens on a trend of being much more specific as to what organizations must do. So in California, we've got 18 specific components of a cyber program that must be assessed, covering areas including authentication, encryption, incident response, service provider oversight, and network segmentation. And so back in the old days, in cybersecurity, it was basically go forth and be reasonable. Right? We start off with data breach notification statutes now in all 50 states. Then there are, and some of them in the data breach notification laws, and then in some standalone cybersecurity statutes at the state level, it's basically obligation to provide reasonable security. Then the trend in, as you mentioned, New York DFS, Massachusetts for a long time was to say, we're going to define what reasonable is. And so California joining that club is really, I think, going to be decisive, that we're going to go from reasonableness and a standard to a rule-based approach. And I think that's really a big deal.
Thank you. And I'd agree. I'll note on those 18 components, because I know we got a lot of public comment on this, the regulations were adopted to say that the auditor deems applicable. So this is to say, an audit won't necessarily have to, in all instances, consider all 18 components. But to Professor Schwartz's point, they're there for a reason. They're there as at least a guidepost of what might be things we should be thinking about collectively, of what businesses should be thinking about. And I wouldn't be surprised if over time we revisit that list to stay up with technology and security threats.
Terrific. So we have some time for questions from the audience. Please raise your hand. And I'll be so delighted to call on you.
Oh, now it's on. Hi there. Thanks so much for being here. Super informative. With respect to the DROP Act, I think that there's a beta part that's supposed to be rolled out. And can you speak a little bit about that and what information businesses would be able to access during the beta phase? And would they, if they access the beta, do they still have until August to comply? And can you give a little bit more information about the hashing and how businesses are going to be able to match that data if it's hashed?
Yes, excellent questions. So to begin, in terms of the rollout, yes, We, in fact, are starting to engage a little bit. We did at least send out to the data broker listserv of all the registered data brokers an opportunity to beta test with us. We're still in the process of developing that out exactly. But one thing I'll make clear. So again, January 1st is when Drop will open for consumers. It's also when Drop will open for data brokers so that they can register, right? It's been an ongoing obligation that every January you have to register with the CPPA. This year, instead of the web form we've done historically, you will create your Drop account and you will register through that account. January 1st, however, the download deletion list and the list of consumers who want to have their information deleted will not be available to data brokers immediately. So if anybody has clients in this ballpark, like you assure them, there's nothing they can do January 1st, even if they wanted to. That said, we do anticipate by this spring, we will be able to open up that component. We're also building out a sandbox in the environment as well, where, to your point, I think, data brokers will be able to come test a connection with our API and test with potentially like synthetic or dummy downloads and uploads the functionality of the system to make sure everything's working before we're dealing with real consumer data. So the plan is spring. Sorry, I can't give you anything more definite than that, but spring 2026, we will open that functionality to data brokers. And then I do anticipate in advance of August 1st, we will allow data brokers to voluntarily start processing deletion requests early. What we don't want, frankly, I don't think anybody wants, is to everybody come in traffic jam to the system August 1st, and then there be some issue either on our end or on your end as a data broker figuring out this API that would cause you to actually end up in a situation where you're not in compliance. So that's generally the plan. Does that answer your question? Okay. Oh, hashing. Actually, I could talk to that real quick too. So the system, how it's going to work at a base level is we are taking consumer information like first name, last name, date of birth, zip code, emails, telephone numbers, things of that nature. Consumer will have the option of how much or how little they want to give us. Consumer could come in and just put in their name, zip code, and date of birth and leave. They could come in and put in 30, no, I don't know, might be 20 email addresses. I'll have to get back to you on that. But they could put in email addresses as well. It'll be really up to the consumer what they want to relay. And then those are going to be segmented into more specific deletion lists. And to the point made, as sort of a security measure, in fact, our system is never going to store that information in plain text. We're automatically going to hash it. I don't think it's a secret to say we're going to use SHA-256, okay? So if you need to know which one it is, that's the hashing algorithm it'll be. And when we convey that list to a data broker, whether it be through an API or if it's a data broker who needs to just do a manual download of a CSV file, they will get those hashed values. And then what the regulations that are at least pending right now require, I can't say they're in effect yet because they're not, so I need to be clear. They've been approved by the board, but are still pending adoption. The requirement is that the business takes that same data set, so to the extent the business has names, date of birth, zip code, and run it through the same hashing algorithm and use that to compare. And if you can imagine, you're never going to match an actual plain text name with a hashed name. You'll only do it if you both hashed on the same hash and there's a match of the exact values of that name. And that's in a nutshell how that process is going to work. And so, yeah, I think that covers it. Okay.
Do you on?
This question actually came up during one of the last sessions. We were talking about risk assessment. And so a question for you, Phil, on the cybersecurity audit requirement. I understand that there were some back and forth. I know, some of the reporting requirements kind of went away or got different sized. I believe the latest one that did get approved still has the annual reporting requirement. If that's true, if you can speak a little bit about it. My understanding is that if you are required to do a cybersecurity audit by April 1 of that year that you're required to do a cybersecurity audit, you're going to have to submit a copy of the cybersecurity audit to the CPPA website. So in addition to the Drop platform, you're probably working on that website filing as well. And that every entity that needs to do a cybersecurity audit needs to report a copy to your office. Not only that, but it needs to be certified by a member of the executive office who is responsible for the cybersecurity audit report. So if you can speak a little bit about that.
Yes, great questions. And again, one that fluctuated through the rulemaking. So I really am sympathetic to anybody who's trying to follow, like, where did you guys land? Where did this end up? So that was very close, but not quite in the sense that, So yes, every April 1st, if you're a business that has to do a cybersecurity audit, you're going to have to submit not the audit itself, but a certification. This will be very basic. Imagine a web form with like a name, and I certify we completed a cybersecurity audit this year. So really, in many ways, it's like a declaration that my business was subject to this, and we did it. We completed it. So that is all that is due to the agency. Now, that said, I'll just share, I don't think it's outside of enforcement's authority to come and request a copy of that cybersecurity audit at some point to assure that you completed the function, or to maybe even review the practices of your business. But at the same time, it is just a certification. We will not be collecting entire cybersecurity audits. At least from my standpoint, I don't want them. Maybe Mike does, maybe the chief privacy auditor will, but I don't in legal. In addition, to the point, originally there was a requirement that actually cybersecurity audit findings would have to be reported all the way up to the board of any business. That was sort of diminished a little bit, or that standard was lowered. So to your point, it is correct. It has to be reviewed at the level of somebody in the executive roles of a business. And the idea is to, the goals of any of this, if anything that felt a little prescriptive, the goal was to ensure independence, right? Was to assure that if you're going to leverage an inside auditor, that it's not a system set up where your auditor is worried their pay is going to get affected because of their findings, or is going to get a bad review from their manager because they've uncovered a big issue or something like that. So what we wanted to do is set businesses up for a situation where they have true independence and can really trust the findings of their auditor, but still leverage somebody on the inside. We didn't want to force businesses to have to go outside of their environment either to do this function if they didn't want to. And then finally, I'll just note, there is a parallel requirement on reporting to the agency with risk assessments. But again, where the agency landed is we don't want, and we are not going to get, I shouldn't say we don't want, some will want, enforcement will want, I'm sure at some point, but I don't want your risk assessment actually. Instead, the regulations describe essentially a summary of your risk assessment activity for the past year. So it'll be things like the number of risk assessments you did, the type of personal information being sort of at stake in those risk assessments, and a number of other kind of key details. But again, imagine probably like a one-page web form that you'll be able to fill out in one sitting, and that won't require sort of the in-depth details of everything that was assessed per processing activity.
Thank you. Another question?
Yeah. I have a question.
Please.
I don't know, again, if you can answer this, Phil, or not, but it's been something on my mind for a few years. Is the agency considering using AI in enforcement? I understand that over at UK, they are doing that.
That is also a fascinating question. And I should start by saying, I'll be honest, I really don't know all the tools enforcement is using. That ends up being, that's on the other side of the ethical wall for me. But at the same time, I can speak to what has been both started kind of with the governor's AI executive order, which applied to state agencies and departments, as well as then the laws that have come up since then. So this is to say, in case people weren't aware, and this includes us, any state department that's going to deploy AI has to do an AI risk assessment before we do it. So don't worry, guys, we're doing it too. We're not just putting the rules on you and not having to do any of it ourselves. We're actually going to have to do our own risk assessments for AI deployment as well. And I don't know, I'll admit, I'm the general counsel that oversaw the ADMT regulations and saw all the scary stuff people were telling us about it in that regard. At least for our agency, we are being very cautious about our deployment of really any technology. I mean, this isn't unique to AI. We really want to be thoughtful. We want to be models of good stewardship of technology and of personal information. So we will demonstrate that as well. So it's not impossible, and maybe down the road, but at this point, I'm not personally aware of our enforcement division using that. But they are using other tools.
Do we have any other questions? Yes, Nancy.
I'm just curious as to how the relationships with those particular other countries, DPAs, happened, and are there other U.S. agencies, either state folks or, obviously at the federal level, we have things in various contexts, but just curious how that evolved.
Yeah, great question. I mean, I have to start by really recognizing our inaugural executive director, Ashkan Soltani. He was a real champion and already a presence in the international dialogue on privacy issues, and so was a real champion of I feel like the relationships were there, and it was more of formalizing them with our agency. And he was one to really want to learn from those that were already doing a lot of the work that we were just starting to do. We're also members. Our agency is member of the Global Privacy Assembly. We're the only state in the United States that has a membership of that because we're the only, exclusive data protection authority in the United States. FTC is also a member of that, but at this point, we're probably a little bit more present than FTC is. But with that said, those are opportunities where we get to come together on an international basis. We're also members of other entities like the Berlin Group, as well as I always forget the acronym, but it's the Asian Pacific sort of alliance, the group consortium of privacy regulators, and coming together in these venues that are sometimes annual or biannual is really a great opportunity to just have those in-person opportunities to share best practices, build relationships, and start to leverage, coordination.
And really very important that the global privacy regulators know about all the positive things that are going on in the U.S.
So this is our first year doing this, and I'd like to thank everybody who really did it. How are you enjoying it? Like, what can we do to improve?
How gracious.
This event? Oh, well, I am a big fan of everything the privacy law section's been doing, I'll just say. Like, kudos to the organizers. They've been doing a fantastic job. I think the programming you do is so important because, again, at least I come from, and I think I can speak for the agency. I know I'm not supposed to speak for the agency. I'm going to do it anyways. We want compliance to happen on the front end. The goal is not to accrue as many fines as we can or to find as many bad guys as we can. The goal is to have a privacy protective environment for Californians. That happens when it's more than just us talking about it. We're a small government agency. Not everybody listens to government. Not everybody follows us on LinkedIn, sadly. So with that said, our goal is compliance, and these events and you all hearing from us and sharing best practices and best ideas, I think are fantastic. Keep it up, please, please. This is good work you're doing, and I think it's going to be growing work, by the way, by result of many of the regulations we just talked about.
So that's really a perfect note to end on. Let me thank Phil. Let me thank all of you for your excellent questions and for your attention. And on to the rest of the program.
Thank you.